This case, my lord, I am appearing for petitioner. The lease was granted in the year of 2006, my lord. Thereafterwards, my lord, that lease has been cancelled on, my lord, 13/6/2008. Then, my lord, we have challenged before this honorable court at page number 23 annexure B, my lord, by filing writ petition. That is 10825 of 2008. Then, my lord, the said rejection order has been set.
What is under challenge?
Please, my lord, now after lapse of 12 years, they have Tahsildar has issued recovery notice without issuing any notice to us, and we have closed in the year of 2008. They have cancelled, and thereafterwards, whatever required is paid. Now, my lord, annexure M, kindly see annexure M, in page number 146. Before that, my lord, in the year of 2015, they have said that there are in survey number 63 of about 300 acres of land, there are scattered stones are found. Therefore, my lord, you are liable to give explanation. Accordingly, we have given explanation to the Mines and Geology Department in the year of 2015. After lapse of 7 years, my lord, this annexure M in page number 146 has been issued. And my lord, I am poor because I could not run. And my lord, I have approached this honorable court by filing several writ petitions. I could not succeed. And 2009, 2010, my lord, ultimately, my lord, your lordship, this honorable court was pleased to reject my claim, my lord, in page number 96, my lord, by this court only. And my lord, 2000.
No, what is wrong in the notice?
Notice, my lord, Tahsildar has, they have to, my lord, if at all, my lord, any allegations, they have to, my lord, give notice to us, where, my lord, that they have to give a survey, and, whether closed query list, that is for the year of 2008-9, nothing has been explained. Only annexure M, my lord, has been issued without giving anything.
Yes, what do you say?
It has reached finality. Last may kindly see. In the year 2015 itself, we issued a show cause notice. He has replied. Thereafter, proceedings are conducted.
He says there is no opportunity has been given.
Yes, it has been given, and ultimately, Lord, now the amount due is ought to be recovered as land revenue.
1 minute.
Now, the notice is issued by the Tahsildar, not from the Mines and Geology Department. Now, on the basis of the letter written by the Lokayukta, now this impugned notice has been issued. In the year 2021, he has not challenged it. And one more notice.
No, we have not, apart from annexure,
during March,
we
it
have
has
not
been issued. During March this year, it has been issued. And he has been called upon to produce certain documents.
I think, my lord, I can clarify your lordship.
The last kindly see 164. Translation is in 165. All that this notice says is, it is noticed to give information along with necessary.
Where are you reading?
166, page number 166. It is the translation of annexure B.
Before that, 124 may kindly be seen for a
minute. Let him finish.
Please.
161.
164 is that is impugned in this writ petition. Translation is starts from 165. Relevant portion is in 166 last paragraph. It is noticed to give information along with necessary document by attending personally to the office within the date 9/3/2022 in respect of the fine amount.
Now, how you say that no opportunity has been given?
No, but this is Tahsildar notice. With great respect, kindly 165 annexure we may kindly be seen, my lord. This is what Tahsildar has issued by virtue of, my lord, they may have written to the Tahsildar. I have not received. Kindly see, my lord, 124 for a moment. Annexure J in page number 124.
This has been sent to you.
Tahsildar has been given a notice for recovery notice, which we have replied to the Tahsildar saying that we have not received any notice from the Mines and Geology Department, and we are not, because my lord, no opportunity has been granted. They should have issued notice saying that, look here, this is the extraction of material which is pending from 2007 and 8. This has not
Did you
been done.
reply to this show cause notice?
My lord,
Did you reply to this?
Tahsildar only recovery notice. That is Annexure B is recovery.
164.
164 is issued by Tahsildar.
in the year-
Tahsildar is, my lord, ultimate recovery agency.
Whatever it is, he first issued you the show cause notice. Thereafter, this recovery notice has been issued to you.
Yes.
Please, my lord, kindly see. With
What
great-
more opportunity is required?
please,
Did you
my lord,
reply to this show cause notice or not?
can I make, my lord, insofar as Tahsildar is concerned, my lord, Mines and Geology Department is the authority to determine the any dues or not. Ultimately, my lord, under revenue, my lord,
Under
under
the-
land revenue, my lord, recovery proceedings has been initiated by Tahsildar. Kindly see, I am permitted to read for a moment. To pay
Under the
penalty
direction
amount,
of the Lok Ayukta,
please, my lord.
the show cause notice has been issued to you, and thereafter recovery has been ordered.
No, kindly Annexure P may permitted to read. This is land revenue recovery notice issued by Tahsildar by virtue of, my lord, a recommendation made by the Mines and Geology Department. I have kindly see for a moment Annexure page number 65. Pay penalty amount of land revenue is as per provision of Karnataka Land Revenue Act translated. The letter of Honorable Lok Ayukta so and so, so and so and so. Then, my lord, kindly see. With reference to the above subject, as per the above reference letter in respect of illegal mining held in the government land of survey number 63 situated at Kanchanhalli village, Bangalore, Begur village, Bellur, Hubli, Nagamangala Taluk, as notified by senior geologist, Mandya district, Mandya to Honorable Karnataka Lok Ayukta to submit report collecting the recovery of 30,40,899. The Mines and Geology Department, my lord, instead of giving notice to us, they have sent to the Lok Ayukta, I believe. And Lok Ayukta in turn forward to Tahsildar. Kindly see, my lord, the Annexure J. Therefore, it is relevant. Annexure J, my lord, 124 is very relevant. Since, my lord, that issued in the year of 2020, 125. 124 is Kannada version, 124 25. The mining work held unauthorized in 125 and translated. With reference to the above subject, that has been found a big deep hole excavated in mining about 900 metric ton held quarry unauthorizedly mining about building stone has spread out here and there in the area of Gomala land survey number 63. Survey number 63 is attached to, my lord, 4 villages, and they are not saying that where that I have extracted. All around about 300 acres, there are spread about the stones. Therefore, they are saying. Then I have given detailed reply. And this reply, they have not answered. There is no speaking order came to be passed. In case if any orders, may not let them place before this court. I have not served. Therefore, my respectful submission is, my lord, this is, my lord, if at all claim is 2007-8, then, my lord, the 2015, I have given detailed representation saying that I have not done. And, my lord, I could not run at all by virtue of there are several orders. And on 6/3/2008 itself, my quarry lease has been cancelled by the authority. And there is no allegation against that I have, my lord, run without license. And if at all, my lord, after determination of, my lord, the payment dues, then they have to give opportunity. Then in case I have not paid, then recovery proceedings has to be initiated through revenue. This Tahsildar directly issues notice to us, Shoka Sanakshariam. This is not permissible.
It is the admitted fact that you could not run the query.
2008 itself.
Could not run the query, could not involve yourself in the mining activities.
Yes, sir.
This is the admitted fact.
Yes, sir.
Then where is how you are challenging these proceedings?
My lord, insofar as, my lord, 2015, they have said, my lord, that scattered, my lord, the stones from survey number 63 has been removed. That is what Annexure J says. Then, my lord, we have given reply saying that no, this is attached to 4 village. Therefore, my lord, I can't, my lord, in Goma land, I am not the authority, or I am not the owner, or I am not doing any activities in the Goma land. They have not, therefore, my respectful submission, no procedure has been followed. In case, my lord, if at all any do, let them give opportunity to us.
When this is the admitted fact that it was illegal mining.
No, I have not admitted, my lord. I have not done.
The year-
My reply may kindly be seen, my lord, for a moment. Annexure J, I have replied.
Reply to what?
Annexure K. Annexure K, 133 page.
The show cause notice was issued in the year 2015.
15. Then I have
Then
replied.
He has extracted 900 metric ton of
That is their claim. That is, I have given
stone
reply.
illegally in Goma land.
I may permit
We
it to
have
read.
sought for an explanation.
Please, my lord, I may
Gave
permit it to
explanation.
read.
There
I may
are
permit
several
it to read.
proceedings are there.
Whatever it is. We are not
My
interested.
respectful submission is, my lord, this is, my
We
lord.
cannot encourage the illegal mining.
No, I'm not doing. I can undertake before this honorable court if they are established that I have done in survey number 63. That annexure J says that is a scattered
You
stone.
cannot take advantage of their inaction.
No, I am not
because the-
taking any advantage. With great respect to this court, my lord, I am not taking any advantage. 2015 show cause notice has been issued, replied, and where is the order? That if they are producing orders, then my lord, they have not produced. They have sent to the Lokayukta and Tahsildar has issued annexure M.
Notice for recovery is with respect to the show cause notice which was issued to you on 7th of March 2022 by the Tehsildar himself.
On the basis of recommendation made by the Mines and Geology Department. Where is the order?
Quantification will
Kindly-
be done
kindly-
by
kindly
Mines
see.
and Geology
That is
Department.
only basis of, my lord,
Whatever it is.
please, my lord.
Whatever it is.
No, for a moment, my lord, this is, I will cause injustice, my lord, kindly see, show cause notice, my lord, annexure M. This is on the basis of senior journalist letter. Kindly for a moment, see, annexure M. This
This
is
show
not,
cause notice which is annexure number P indicates that it is with respect to the letter of Lokayukta
yes,
dated 19th of
this is in continuation of annexure M. In annexure M may kindly be seen, my lord.
annexure M may be with respect to the
Same
proceedings which
amount,
were
same.
initiated by the mines and
Kindly see it translated. To pay penalty of rupees 30,000 for 30,44,899 imposed in connection with illegal mining held by you in the government Goma land 63 of Karnataka so and so. Reference letter Mines and Geology dated, my lord, 9/6/2021. This letter I have not, sir. The letter of Honorable Director to Department of Mines and Geology, Bangalore, while letter dated 27/4/21. This letter, my lord, has been directly issued to the Tahsildar. Before that, they have to give opportunity to us and they should have demanded this amount has been imposed. Nothing has been done.
all right. Third,
My respectful submission is, my lord, since, my lord, kindly for a moment, there are 3 cases. And in case, my lord, I'll undertake before this honorable court if they are able to, my lord, produce those documents that which they have written to the Tahsildar and, my lord, the Lokayukta without giving us an opportunity. And, my lord, this is, my lord, ultimate, my lord, violation of KMMRC rules, procedure, and, my lord, imposing penalty without knowing me. Let them produce that documents, my lord. Let them produce that documents. That letter which they have referred. Otherwise, I will get injustice, my lord. I could not run the quarry lease at all. Now, if they are imposing and Tahsildar is initiating recovery proceedings under land revenue by virtue of letter, and I will lose my property, agriculture property.
if you want, we can give you time to deposit.
My submission is, my lord, for a moment, my lord. Let them produce that letter which they have given.
Nothing. Otherwise, nothing. Take down. The notices.
I'll consent, have
Correspondence
day
shall
after
be
tomorrow.
accepted
have it day after tomorrow. I'll consent party and my lord, since my lord, the,
petition, not after arguing the matter on merit.
no, my lord, then my lord, for a
Now,
moment,
please don't do all this. The writ petition has been filed seeking following relief. Learned counsel for the petitioner submits that the impugned notices have been issued without providing adequate opportunity to the petitioner. It is also submitted that the notice dated 7th of March 2022 was issued on the basis of the letter of the senior geologist, Mandya district, reporting the illegal mining done by the petitioner and for which the recovery of 30,40,899 is required to be made. The submission is that the senior geologist Mandya, before referring the matter to the Tehsildar Nagala Taluk, had not given opportunity to the petitioner, and as such the entire recovery proceedings are bad in law. Learned AG, on the other hand, on the basis of instructions, submit that way back in year 2015, a notice was issued to the petitioner by the Department of Mine and Geology, calling upon him to show cause as to why penalty should not be imposed on him for involving in illegal mining at, what is that site? Site is
survey number 63 in there.
63.
That is about 300 acres.
Kanchanahali village, Velluru, Hubli, Nagamanna Gala Taluk.
Show cause notice at annexure dated
Annexure
29.
reply has been issued.
The petitioner had submitted a reply which was duly considered, and thereafter the decision was taken that he has been found involved in illegal mining. It was pursuant to the direction issued by the Karnataka Lokayukt wide letter dated 19th of June 2021 that the respondent number, Tehsildar is respondent number 4, has initiated the recovery proceedings and had issued the show cause notice to the petitioner. The notice of recovery has been issued after adopting due procedure of law, and it does not call for any interference. We have considered the submissions made by learned counsel for the petitioner as well as learned AGA and gone through the record. As per the facts of the case on record, the petitioner was granted a query lease on 17/4/2006 for a period of 5 years in respect of survey number 63 of Kanchanahali village, such and such. Subsequently, the said query lease was cancelled
On 13/6/2008.
by issuing cancellation order dated 13/6/2008. It was challenged in WP number 10825 of 2008, which was allowed by the writ court. Thereafter, the third respondent had passed the order confirming the cancellation of querying lease. Petitioner had challenged the said order dated 22nd of December 2008, in WP 1540 of 2008, the State Court was pleased to remit the matter to the third respondent for fresh consideration. It was thereafter that the third respondent had again confirmed the cancellation of query lease. The said order dated 16/6/2009 was challenged in WP 25521 of 2009. However, the said writ petition was ultimately dismissed. The admitted position emerges that the petitioner could not run the mining activities after cancellation of the order dated 13/6/2008. The petitioner had made application for revival of crusher unit. However, the competent authority had not allowed the same. The writ petition preferred in this regard by the petitioner, that is WP 2183-2185 2013,
That's crusher unit.
was disposed of.
Yes. Crusher unit.
Directing for the respondent to pass a fresh order. It was thereafter that for the respondent has passed the order for reopening of crusher unit
That is in
on
respect of
annexure.
some other pressures.
1/2/2013.
Annexure
It is
H
to be noted that the running of crusher unit
has been closed once again.
and the mining activities at survey number 63 are altogether different activities. It is submitted by counsel for the petitioner that the respondent have not addressed towards the allegations regarding the illegal mining done by the petitioner and have not passed any final order
After annexure
after
G.
submission of reply to the show cause notice issued in the year 2015.
29-1.
He has not been able to show any order by which he was permitted to do the mining activities,
Except crushing, annexure H.
and as such, it is the admitted position that after cancellation of query lease dated 13/6/2008, the petitioner could not have involved himself in the querying activities. Full stop. In this view of the matter, we are of the considered view that the proceedings initiated for recovery by the fourth respondent do not call for any interference by this court. The writ petition, being devoid of merit, is dismissed.
My one submission, my lord, the insofar as, my lord, the final order which they have passed, which is not even served and not placed before the, what is the determination and all. This is nothing but, my lord, regularization, whatever they are doing, my lord.
All right.
Yes.
We have passed
Bill
the
number
order.
2, to Sushal Tiwari.
Venerama.
appearing for the appellant's counsel, my lord.
Rajgopal, you appear for?
Appearing for the appellant's counsel.
None.
Leading
Yes.
My lord, page 19, my lord, is the order of the learned single judge. How the matter
Page-
arisen was, I am the owner of a property. Page 19. 19.
19.
Yes, 19. My lord, may kindly go to page 21, my lord, paragraph 3, may kindly be seen. The learned AG upon instruction submitted. Prima facie, it has been found that the petitioner encroached upon the government property. Action has been initiated to have him evicted from the same. In the process, after inspection, a report has been submitted to Lokayukta wide Annexure G to the writ petition, and a notice is issued to the petitioner Annexure K to the writ petition, calling upon the petitioner to show cause why proceedings under section 192 of Karnataka Land Revenue Act should not be initiated against him by virtue of sections Annexure K to the writ petition. May kindly see section 192 for a moment. How the matter was arisen was, I am the owner of the property. It is 1 acre 21 guntas. I acquired by lawfully minimum. Then land in question was converted to the non-agriculture purposes. I constructed a commercial complex after obtaining the license. After construction, my lord, what happened was some complaints have been made to the Lokayukta by third party. He alleged.
What was your grievance? Why you had approached the writ court? What was your grievance?
Annexure K, a notice was issued calling upon me to demolish the construction on the basis of the Lokayukta report. I said if there is no encroachment, if at all a Lokayukta passes an order, based on that no order could be made, I have to be called upon to explain and the inquiry to be conducted. Any encroachment that has to be determined. Without it determining that, notice was issued to demolish the construction is illegal is my complaint. Learned single just said, you go and explain to the concerned Tahsildar. My lord, very issue is already pending before this honorable court, where there is an interim order is there. Could your lordship may kindly go to my lord for a moment?
No, the learned single judge has taken the view that it is not a final order. It is only a show cause
Precisely,
notice.
my lord, what the learned single judge could have been done is,
Right.
no, why my submission is, page 98 may kindly be seen for a moment. An issue is pending before this honorable court. There is an interim order. Tahsildar is a party. Petition is pending. Very issue is now Tahsildar wanted to crop up when in another way. That is the grievance we addressed before the learned single judge. It was not considered.
Where is that matter?
Annexure 98, page 98, Annexure H may kindly be seen. It is the notice issued by the village panchayat to remove the building on the basis of the Tahsildar's instruction. Translation is at page 99. There is an allegation that may kindly go to page 100.
Same land.
Yes, same land. Same land, same dimension. Annexure.
This was challenged before this court.
Yes, page 102, my lord. Annexure J is the order of this honorable court. There is an interim order, page 103. Consideration of these submissions, last but one paragraph, on perusal of the impugned order dated so and so, operation thereof is stayed until further orders. Now this writ petition is still pending also. It is in respect of very subject matter that was brought to the notice of the learned single judge.
Is what you say?
Lords, let him reply, my lords, including this 103 interim order granted, my lords, to the building based on the panchayat has issued, saying that
No,
the
matter
building,
is sub judice here.
yes, matter is subject.
Then how?
But I don't know, my lords, whether brought to the notice of learned single judge or not.
It is a
It's not
part of the record, my lord. We have produced annexure J. We have pleaded in the writ petition.
Any of my lords,
Documents are
cause notice, lords may say that let him go and explain this also. Let the Tahsildar consider this interim order also, my lords, while arriving at a conclusion. Because he cannot, my lords, one authority cannot be stopped and
But
another.
he will consider when the matter is sub judice
Yes,
here.
he cannot, my lords.
Then
Is there? For building, my lords, there is a hint. It's only merit, otherwise, my lords, there is no absolutely. All reports say that, my lords, there is a government encroachment. of the
Whatever
order.
it is now, there is an interim order.
Yes, interim order is there.
We will connect with this writ petition. The petition would be connected along with this writ appeal.
Yes,
Let the matter come up.
till such time my building, the existence of building to be protected. Now when order is passed by taking police assistance,
We will restrain them from taking any action on the
I'm
basis of this.
grateful,
law.
I'm grateful.
This inter-court appeal has been filed. Challenging the order dated 21st of April 2022 passed in WP 8044 of 2022 KLR RES, whereby the writ petition preferred by the appellant petitioner has been dismissed by the learned single judge. Learned senior advocate appearing for the appellant submits that the subject matter regarding which the impugned show cause notice dated 22nd of March 2022, which was under challenge in writ petition, issued is sub judice before this court in WP number
103.
10302 of 2021, Annexure J, page 1.
of 2021 KLR RES, wherein while interim order dated
18th June.
huh?
18th June 21.
18th of June 2021, the order under challenge dated 18th of March 2021,
18/5/21.
18th of May 2021 has been stayed till further orders. Admit, issue notice to respondents. The learned AGA shall accept the notice for respondents.
1 and 2.
1 to 3 minutes.
Panchayat.
Huh?
3 is Panchayat.
Yes. 1 to 3 minutes in appeal. Here, Lord Session Commission is shown as a 3 in my paper.
No, in the writ appeal. Writ appeal, one.
Yes, all respond.
One. It's what you written. You may file the response within 3 weeks. List along with list after 3 weeks along with writ petition number, the earlier one, such and such.
WP number 10302 of 20.
In the meantime, the next date of listing, the respondents are restrained from taking any action on the basis of impugned notice dated. What is the date?
Next year, K minutes. Date.
22/3/2022, Annexure K.
Dated not 22nd July 2021.
Hmm?
11th not page number 12.
You speak in the manner so that I can understand.
Please. The
Where is the writ court order?
That is my lord, annexure A, my lord.
Page,
Page, Lord, it starts from page 9. Relevant portion, Lord, is at page 12, Lord.
yes.
Last 3 lines. Hence, I number 3 of 2019 is hereby allowed. Respondent is directed to remove the compound wall put up enclosing the suit scheduled property. This order, Lord, is violated, Lord, by the accused.
Who was the respondent?
Respondent, Lord, it's a college.
And
Lord, represented by Lord, the DP order, Lord.
remove the compound wall put up enclosing the suit property.
This was passed, Lord, by hearing both sides.
Hmm?
After hearing both the sides, Lord, this order was passed.
Hmm.
They had contested the application. Thereafter, Lord, the application was allowed.
Hmm.
Even then, despite lapse of more than 1 year, they have not complied the order. The notice was also issued. Despite service, Lord, they have not acted. That's why, Lord, they present contempt.
This order has been passed in the proceedings. First appeal.
In a first appeal.
So how the contempt will lie?
It was under, my lord, application was under section 151, Lord. It's not under order 39 rule 1 and 2.
Contempt will not lie.
39 rule 2A is not maintainable, Lord, because it
Why?
was passed under section 151 of CPC.
Where is the law that in case the order has been passed under 151, therefore you cannot move any application under order 39 rule 2A? Is there any such law?
If it is passed under 39 rule 1 and 2, only then, Lord, 2A is maintainable. With that liberty, Lord, contempt.
Huh?
I'll file, Lord, because the learned signal.
You wanted to take a chance. Huh?
No.
Civil matter. Civil matter, they can move that civil court.
You want to withdraw?
With liberty, my lord, of approaching the lord.
This contempt petition arises out of order dated such and such, passed in RFA number such and such. Then a counsel for the complainant petitioner, after arguing the matter at some length, makes a statement at the bar that he may be permitted to withdraw this contempt petition with liberty to move appropriate application before the court concerned. The contempt petition is accordingly dismissed with aforesaid liberty.
Kindly seek a password in this matter. This is a matter, my lord, on Friday, lordship has passed an order. My lord. The order is complete, my lord. The affidavit is also ready, my lord. Kindly pass it on. Order is complete, my lord.
You are obliging the court.
My lord?
Obliging the court by complying the
No,
order.
no, not like.
Yeah. Some people don't improve, like you. That day you were being sent to jail. Now 24 hours time was granted to comply.
Yes, complete, my lord.
Now there is nothing to show that order has been complied.
It has been complete, my lord.
You can't help it.
Last 2 days being holidays, my lords. Today morning they came with that report, my lords. So I have
This is how
affidavit
you-
is, they are swearing
How
in.
seriously you take the court?
Sorry, my lords, no. Take it with utmost respect and seriousness, my lords. Kindly, my lords. Short pass on. In 5 minutes, my lords, they will bring that.
Pass over.
Lord, appearing for the petitioner in this matter, my lord. The objections have been raised, my lord, for a translation. I will make necessary compliance, my lord. 2 weeks' time may be granted to make the necessary compliance, my lord.
For compliance, on last date you did not appear.
No, it was actually posted in another court, my lord. It was posted before court. Wherein Kannada translation was not required.
Time was granted, you did not rectify the objections. That means you are not serious. We are dismissing the petition.
No, my lord, it was posted before the Honorable Justice Dinesh Kumar had presided over, my lord. Therefore, in that translation was not necessarily supposed to have been filed. It was not initially raised as an objection. Now it has come before this honorable court and the objection has been raised, my lord. Therefore, 2 weeks time to make the necessary compliance. Item number 5 and 6.
What is your name?
My name is Nitin, my lord.
Nitin. AM, counsel for complainant petition undertakes to make good the office objections within
2 weeks, my lord.
2 weeks.
2 weeks, my lord. Yes. Translation.
Then we are not-
I left translated copy, my lord. No problem.
Sorry.
At least 1 week.
Then we are dismissing the petition.
It is a memo that 1 week time may be granted for me to file the translated copy of that order.
Then we'll dismiss your petition. Not 2 weeks time. That shows how serious you are.
I personally do not know to translate, my lord. I have to approach a translator.
In January 2022, you had filed this petition.
My lord, this
Now we
matter
are-
was decided before another judge wherein Kannada translation was not required. Only the Kannada part has to be translated, my lord. Now, for the first time, it has come before this honorable court, and therefore translation is required. That is why fresh objections have been raised. These objections were not raised. Now, recently, these objections have been raised.
1 week time, if you want, you can remove it. Otherwise, you don't remove
I will make necessary amendments, my lord.
A week's time to make good the office objections positively. List, give it date.
Item number 6.
Same position.
Same position.
Same.
Number 7.
There is some objection in the LR application.
Yes.
I'll remove it within 2 days. Full cost title is not furnished. I'll remove it.
You want to make good the office objections?
2 days.
Give time. 1 week. Next.
Number 8. Prasanna Kumar CS. Prasanna Kumar.
I appeal to the appellant, my lord. Complainant.
Yes.
The respondent who has filed a complaint affidavit has not complied with the office objections.
With your lordships kindly, my lords, in serial number 8, I appear.
Yes.
With your lordships kindly. My lords, in serial number 8, I appear to the contesting respondent, my lords. My lords, we have issued an endorsement and also made an allotment, but there is some minor office objection in terms of office noting which we have filed, which is in Kannada. My lords, if a short accommodation is given, I'll file the translation of it. Nevertheless, my lords, to show the compliance.
1 week time granted to make good the office objections.
Deeply obliged, my lords.
Number 9.
My lords, in serial number 9 also, I beg to appear for the contesting respondent. My lords, there as well, we have issued our endorsement. Again, that is in Kannada, my lords. I seek indulgence, my lords, in terms of a week's accommodation to file a translation, my lords.
1 week time granted to.
Deeply obliged.
Serial number 10, I appeal for the complainant, my lord, that they passed an order on 13/4/2022. I may be given liberty to challenge that order and the contempt questions may be dropped. I filed a memo to that effect.
Accused number 1 and 2.
What was the order?
The 13/4/2022.
What was the order of the representation?
Yes,
Representation
To consider the representation of pass orders in accordance with law.
Have you
That
filed
has
any-
been complied with.
Have you brought it on record?
It was an ex parte order, a review petition was filed.
You have, in the compliance affidavit, you have annexed the order which has been passed on representation.
Yes, yes, which has.
That is 13th of April 2022.
Yes, ma'am.
This contempt petition arises after order dated such and such, whereby a direction was issued by the writ court to consider and decide the representation of the petitioner, complainant petitioner. Within 8 weeks from the date of receipt to certified copy of the order. Para. A compliance affidavit has been filed by the respondents enclosing the letter dated, endorsement dated 13th of April 2022, whereby the representation of the petitioner in compliance of court's order has been considered and decided. In view of above, nothing remains to be complied. The contempt petition is accordingly dismissed, notice discharged.
That I may be given liberty to challenge that order because it is rejected.
The liberty is given to petitioner to challenge the order dated, endorsement dated 13/4/2022 in case he feels so.
Obliged.
Number 11,
11 is also the similar order.
similar matter, wherein it is complaints of.
Same order,
Same order.
date, same.
Date is different. Date.
The date is, the order is different, but the representation date is same. Lord.
Representation, the endorsement are same.
Same date. Same.
Obliged.
Number 12.
I am here for the complainant, my lord. Because the interim order passed by this honorable court is violated by the respondents, my lord. The order is at page 52.
Yes.
Lords, my colleague has accepted, my lords, he was there. Notice, formal notice is not ordered in the contempt proceedings. My colleague has accepted notice, my lords. We need some more time, my lords, to file a counter to say that, my lords, we have not taken any coercive step. Interim order says that you shall not take any coercive steps against the petitioner's hearing, complaint hearing. We have not taken that, my lords. I'll file that affidavit. And we are moving single judge, my lords, to modify that order and consideration for the, my lords, final disposal. There is a,
They are saying that they are not taking any action.
my lords have furnished a list at Annexure G, page 86. They have seized the vehicles of the complainant organization. So it is nowhere in the list shows that it is the petitioner's organization. That is a difficulty, my lords, what he has given the just list of the vehicles, but that does not refer, my lords, whether they are the petitioners or not. Yes. Plus this interim order, my lords, with great respect, my lords, I will make the submission. My lords, it is without any proper framing of the rules, my lords, they are allowed to, my lords, use as a taxis.
Just a minute, where
Please.
is the order?
Page 53, my lords. Page 52, my 52 it starts, plus 53 is the,
52.
yeah, yes, sir. Last paragraph of the order, 53, page 53. Meanwhile, state response are directed not to take any coercive steps against the petitioner till next date.
Now I suppose they had already seized some vehicles. Then will it, this order will this mean that they all have to be released?
This is after the order, my. seizure of vehicles has taken place pursuant to this order.
Where you have said?
My lords,
Why don't you decide the application for permission?
my lords, application for permission can be decided. They are the two-wheelers, my lords, wanted to use as a taxis. For that, my lords, we don't have a rule. My lords, a single judge, my lords, allowed the my lords, granted interim order in such a way that on the basis of interim order, my lords, that they are running as a taxis. And my lords, we will be as a my lords, Rapido, they will come. My lords, will
There
not
is
be
no rule to grant permission.
My lords, there is no rules. My lords.
So you cannot restrain them from running the vehicles?
My lords, unless they have permit, my lord, they cannot. For that, my lords, we are moving the single judge. My lords, the date is fixed now on 24th, my lords, before the single judge. We are requesting single judge to take up the matter finally. Otherwise, my lords, court is permitting them as a my lords, permit, and they are running. My lords, we will not be as authorities. My lords, will, if we stop, assuming my lords, a driver without my lords, helmet rides, my lords, we stop. My lords, they will rush to this honorable court and say that this is a contempt. This is a difficulty. My lords. For that reason, my lords, we are moving the single
Is
judge.
there any rule to grant permit?
There is no such rule for the two-wheeler as such. My lords, there are rules which says that electrical vehicle we are permitting, not the my lords, fuel vehicles. That, my lords, they are not using here. All these, my lords, legal issues are required to be searched before single judge. For that reason, we have moved, my lords. Now 24th is the date. Lord single judge agreed tentatively. My lords, he is taking over.
That rules are required to be framed.
For the my lords, vehicles, my lords, other than the electrical vehicles, rules are required. My lords, we are permitting, my lords, vehicles which are based on the electrical vehicle. That, my lords, these are the channels what he has produced at Annexure G are the regular two-wheelers.
Have you filed any affidavit?
No, my lords, I have not filed. My colleague has taken the notice. I'll file the affidavit. My lords, may grant
File
1
the
year.
affidavit, then only.
I'll file the affidavit. I'll file the affidavit. My lords, may grant 10 days time.
Whatever defense you want to take,
I'll
take it. Then only.
Grant me 10 days time, my lords. Meantime, my lords, we are.
Learned AGF transfer is allowed 2 weeks time
Please, grant.
to file the affidavit, counter affidavit. List 2 weeks.
Serial number 13, 14 and 15. In serial number 13, 14 and 15, the direction was issued to the appellate authority to dispose of the appeal within 3 months. The appeal could not be disposed of. An application for extension was moved before the learned single judge. The learned single judge has granted time till 21/6/2022, on which day the board meeting is held, scheduled to decide the appeals. The time has been extended.
22.
21/6.
21st June.
Next week, 21/6.
Now this content will not survive.
But in case, you have the submission.
No, we'll record.
My
We will
undertaking
record
Yes, yes, madam. Yeah, I was also present when this submission was made before the
this contempt petition arises out of order dated such and such, passed in writ petition such and such, whereby direction was issued by learned single judge. Page
Page number 11.
12.
11.
to decide the petitioner memorandum of appeal dated 27/7/2019 and pass a speaking order within a period of 3 months in terms of Regulation 34, Karnataka State Road Transport Corporation Servant Conduct and Discipline Regulations 1971. The counsel for respondent on the basis of instructions makes a statement at the bar that on an application preferred by the respondent, the time to decide the appeal has been extended till 21st of June 2022. It is informed that board meeting is going to be held on
21/6.
21st June 2022. On that date, the representation of the appeal of the complaining petitioner would be considered in terms of the writ court directions, and appropriate orders would be passed. In view of above, we dispose of this contempt petition with observation that the respondents shall comply the writ court directions within the time period prescribed by the court.
All three. In the other two cases, the date of appeal is 26/7 in both the appeals.
In
The next two. In the next.
other two, the date of appeal would be
26/7.
26. These are this 13, 14, 15. 13, 14, 15.
Number 16, Saranayas. Rejoinder is filed without order.
You have find it. Fix the date for hearing.
Recall. After last 2 years, they have filed an application to recall the order.
Who has filed?
We have petitioner as
What is the order which you want to be recalled?
2/3/2020.
The petition was dismissed in default. You have filed the
Objection.
matter is to be heard on that application. What do you say?
For accommodation. Standing counsel is becoming.
Attend on the request counsel for the petition. List in the month of July.
Objections on affidavit is
Objections on affidavit are taken on record.
Number 17. Java 14%.
Yes, my lord. I am appearing through VC, my lord. My advocate has filed a memo for retirement. I may be permitted to appear, my lord.
He has moved in application.
Advocate has filed a memo for retirement, so he wants to pursue the matter.
You have moved the application.
Had
Memo for retirement.
Yes, my lord.
Will allow it.
Please, my lord.
Memo of retirement moved by such and such is allowed. The party in person. The petition is to appear party in person. List on such and such date on that the name of council such and such shall not be shown.
28 July. Number 18.
And I appeal for respondents 2 to 4, my lord. Respondents 2 to 4, accused number 2 to 4, my lord, I appear. My lord, there is a direction by the Lord Single Judge for reinstatement of the petitioner, my lord. We have reinstated the petitioner, my lord. Only, my lord, the another direction is to pay the 25% of the back wages, my lord. But that has been assessed, my lord, on 10/6/2022. They have worked out what is the back wages, my lord. It will be paid after some time, my lord. Because it is a Gram Panchayat, my lord. It doesn't have so much of funds, my lord. So, my lord, they will work out, make a provision for that. And so I pray for a 4 weeks time, my lord. That will also be complied.
What do you say?
Please.
Or there will counsel for the where is the order?
Page number, my lord. 32, my lord, Annexure C. Page
The
32,
operating
Annexure
portion
C.
is at 42 minutes. Operating portion is 41 and 42 minutes. Order is Annexure C
This
32.
petition arises out of order dated such and such. Petition such and such, whereby direction was issued to respondent implement the order passed by the appellate authority within 6 weeks from the date of receipt of certified copy of the order, reinstating the petitioner into service. It will also directed that for the interim legal period, that is 2014-2021, the petitioner shall be entitled to 25% of the back wages. The parallel counsel for the respondent submits that the petitioner has been reinstated in service so far as the question of payment of 25% of back wages as directed by the writ court is concerned. A decision has already been taken and wide order dated.
My lord, they have sent a communication to me, my lord, on 10/6/2022. That is on Thursday, on 10th of June, my lord.
Communication is not required.
On 10th of June,
when
my
they
lord.
have taken the decision, do you
Yes.
have the details?
Yes, my lord. On 10th of June, my lord, they said the 1,66,000 and odd will be
Don't
paid.
write the date. Taking decision to such, and the payment would be made shortly. He may be granted 4 weeks time to submit the compliance affidavit on the request of counsel for the respondent. The matter is adjourned for 4 weeks. Just thereafter.
Still number 19, John D'Souza, 14%.
For the respondent in this case.
Like to submit few facts within few minutes. My
Before-
lord, at the age of 69, I am facing 6-round litigation from 2002 to 2022. The Honorable Court found urgency in this matter in the year
It is to be heard
2016.
finally. It is,
Lordship, Lordship, may I make a submission? Lordship?
Yes.
Today, I have filed my power on behalf of the respondents below.
yes.
I need 2-3 weeks of accommodation for filing of my statement of objection because they have served the voluminous documents below. So,
You are appearing for the
I served
first
office
time.
2 months
the first
back.
time, Lord.
Appearing for the first time.
First time. The matter has been listed before the Honorable Court for the first time. I am appearing for the first time, Lordship.
You are appearing for divisional controller.
For the respondents, Lord. I filed my power today only in the morning, Lord.
What is your name?
My name
Many
is-
occasions I contacted the law officer and also the counsel.
HR Renuka.
SB Shrikant, Lord.
SB
Shrikant.
Srikanth has filed wakalat on behalf of respondent. He pays for is allowed 2 weeks time to file the statement of objection.
Much over.
No, the statement of objection. The response.
Much over.
File the response to this appeal. List thereafter.
I will fix a date.
Give a date after 2 weeks.
12th July.
Much over.
Number 20, Kumar Jesse.
Sir, I filed the petition. Direction to the respondents to consider the representation for making 15 gross million. If the representation filed in the year 2017, they have not considered. Therefore, the petitioner have filed the writ petition in the year 2020, seeking direction, and direction is given on page number 10, my lord. Relevant portion.
Yes.
That's why I filed the affidavit. In para 3 of the affidavit, I have stated that ODI and Durusti work is already commenced, my lords. We have, my lords, grant order Either petitioner has to produce or, my lords, it is not available in the office. For that reason, to reconstitute, my lords, the grant order and record, we have sent a communication to the Deputy Commissioner. Paragraph 3 of my counter.
3. Can you read?
Please. I most respectfully submit that after considering the request of the complaint herein for Podi and Durusti work of the land in question, I have issued the endorsement to the complaint stating that since the original land grant records in respect of the land in question are not to be found in the office of Tehsildar, the case of the complaint is referred to the committee for reconstruction of the entire file. A copy of the endorsement issued by me and a copy of the letter written by for the purpose of construction of the file to the Assistant Commissioner dated so and so are produced as annexure R1 and R2. I most respectfully submit that immediately committee for construction of the file consider the case of the complaint.
What happened thereafter?
Because thereafter committee members has to give me input based on the Xerox copies they will.
No, this was in 10th of March.
Yes.
Now again 3 months have passed.
Millers, unless the order of the
Now whether the file have been constructed.
No, Millers, that process is on, Millers. Another 2 months time, because order says that in accordance with law we have to consider. Unless the land is granted, Millers, the 4D we cannot do in the government land. That is, Millers.
AGA on the submits that they have filed the affidavit indicating therein that the relevant records pertaining to Podi and Durasti work of land in question is not available. The respondent has already ordered for reconstruction of file to the Assistant Commissioner. In this regard, the order has been issued on 10th of March 2022 and 31st of March 2022. It is submitted that as soon as the file is reconstructed, the case of the complainant would be considered in accordance with law and appropriate orders would be passed.
Please.
It is submitted that 2 months further time may be granted for the purpose of compliance of the writ court order, considering the fact that the relevant records are not available, due to which the order passed by the writ court could not be complied. We adjourn the matter for 2 months, list after 2 months.
Right.
Number 21.
Yes.
There is some practical difficulty. A temple is there, there is a known temple in Melkote, where Ramanujacharya installed the two deities. The question is whether a Badali Archak, a substitute Archak, can be posted when there is pollution in the amongst the priests in charge. Whether there's a death in the house, there is pollution. Like this, for that limited period of pollution, a person is appointed somebody. The Labrador Single just says is a regular appointment, is overweight, overeducated. That requires consideration. Now we have received some documents which require to be placed before the Lordship. Please grant me 2 weeks time.
2 weeks?
Yeah. Maybe they're all in Kannada. They require to be translated, made available 2 to 3 weeks.
Adjourned on the request of learned senior advocate appearing for the appellant list after 3 weeks.
Number 22. Prakash PS.
Thank you.
Complied. This petition, this contempt petition arises out of order dated 19th of November 2021, passed in writ petition number 20436 of 2021 GM MMS, whereby the respondent are directed to pass orders within a period of 6 weeks regarding the
Of license for stone.
consequential orders in accordance with law as per Rule 3(2) in bracket 2 Karnataka Regulation Stone Crusher Rules 2012 pursuant to the certificate of pursuant to the certifying of proposed place for establishing stone crusher and a notification of safer zone having been issued. The London AG appearing for respondent has filed a memo. You should better file compliance affidavit, not memo. How can we understand whether this amounts to compliance or not? Huh?
Supposed to file. Last
In
minute,
contempt proceeding, this is not permitted, memo.
yes, I understand. Last minute I received a not file affidavit.
Makes a statement at the bar that in compliance of writ court directions, while order dated, this is the license
License in Form C.
12/5/2022, license for stone crusher has been issued. The copy of the license for stone crusher dated 12/5/2022 has been brought on record. London Counsel for the complainant petitioner submits that the order of the writ court is stand compliant. In view of above, nothing survives in this contempt petition. Contempt petition is dismissed. Notice discharged.
Number 23. Telecast Goda.
Not the order suspending the complainant may not was under challenge before the learned single judge. And my lord, the learned single judge, my lord, by way of an interim order, states the operation of the suspension order. That order is at page 13, my lord.
13.
Yes, ma'am.
30 or 13?
13, 1-3.
1-3, yes.
But in spite of this interim order being communicated, my lord, to
Shall be
the
an interim order with stay of the operation execution of the impugned order of suspension. You were working on what post?
the complainant, my lord, was working as superintendent, my lord, in Karnataka State Open University. My lord, I may bring one subsequent development, my lord. This order, my lord, was on 7/3/2022. I'm sorry, my lord. This order is 28 March 2022. This was communicated, my lord, on 1st April itself.
What is that?
My lord, that is page 36 to lawyer's notice and also to at page 38, annexure B. But my lord, later on, my lord, on 20th April 2022, an order is passed reinstating the complaint. That is after filing of this.
Page? Page?
My lord, this order being communicated is at page 36 to lawyer's notice.
30?
36.
Where is that you order passed that reinstating?
That is not, my lord, that is subsequently done on 20th 4/2022. That is not part of the record. That is done subsequent to filing of the contempt petition.
Then what remains?
Only the thing is, my lord, they have driven me to file this contempt petition.
Oh.
Later on, they have reinstated.
What do you want cost to be imposed?
Because, Lord, though being communicated through lawyer's notice as well as.
On your statement, we will dismiss this contempt. This contempt petition arises after order 28/3/2022, whereby the order of suspension of the petitioner dated 7/3/2022 was stayed by the court. The next date of hearing. Counsel for the complainant petitioner submits that the order of the writ court was duly communicated to the respondent. However, they did not comply the said order. It was only after filing of this contempt petition that they have complied the writ court order and they have reinstated the petitioner by order dated
24, 2022.
24
2022. 20th April 2022.
20th April 2022. Full stop. In view of above, we are satisfied that the order passed by the writ court has been complied. As such, nothing remains in this contempt petition. Contempt petition dismissed, notice discharge.
24, A.V. Amarnathan.
Moving time was granted to the third respondent to file the counter. The second respondent will give small instruction.
But in this matter, 3 departments are involved. One is BWSSP, which is represented by
Until the direction come to that, we are not concerned.
Yes, my lords. The direction is, my lords, on 13/4/2022.
Where is that order?
21/4/2022.
Page 10. Order passed in writ petition.
21/4/2022.
This is PIL.
Yes, WPT.
This is PIL.
There is no system of listing of cases. One matter will come as writ appeal, other will contempt, the third is PIL. You cannot understand. All of a sudden, PIL, now it comes. Now,
Your lordships ordered it at 13.
direct the respondent to take up the work of forming the park on the open land available on the either side of Kaveri pipeline,
Yes,
passing through Vasant Vallabha Nagar.
yes, ma'am. Subsequent to this, my lords, there are 3 departments which are involved. One is horticulture department. One is BWSSP, which is represented.
Just a minute. On the last date, it appears that you said that
Action plan.
submit the plan which has been approved to develop the area on either side of Kaveri
Yes, ma'am.
pipeline.
Lord, this pipeline is laid by BWSSP, my lords. The officers of horticulture department who will lay the park and the BBMP officers and BWS officers have convened a meeting, my lords. Now, my lords, after this, now they are in the process of preparing a plan, keeping in mind that days which is involved for all the agencies. My lords. That meeting is convened, my lords. That proceedings I'll file it, my lords. Because it is all interconnected. We make the paths. Horticulture department will lay the trees, and BWSSB is to give NOC.
You appear for?
BWS.
Respondent number 2. In 2018, representation was given to CM. CM had directed them to do it. In the past 4 years, no progress is there.
No. Pipes are laid.
Learned counsel for respondent number 2 as well as learned counsel for respondent number 3 submits that it is a joint work of 3 departments.
What?
3 departments.
Yes, horticulture department,
Horticulture,
BWSSB,
PWD,
BWSSB, and BBMP.
BWSSB, and BBMP.
Engineering department.
The meeting has been called between these 3 departments to formulate the action plan.
Yes.
The status report would be submitted on the next date.
Yes.
On his request, case is adjourned. List after 3 weeks.
Appealing for petitioner, my lord, I have submitted this petition seeking for a writ of mandamus to the respondent number 1 to 4 to consider the representation submitted by the petitioner under section 63 to 73 of the Karnataka Land Reforms Act to find out the illegal holdings of agricultural land.
We are unable to understand what you are arguing. Your voice is not clear. You physically come and then argue the matter.
Please, ma'am.
List in the month of August for final hearing.
ನನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸರಿಯಾಗಿ ಕೇಳಿಸೋದಿಲ್ಲ ನೀವು ಬಂದು ಇದು ಮಾಡು ಅಂತ
The petitioner was granted a mining lease for mining the sand for a period of 1 year.
The matter is to be heard finally. It is not a regular bench. It will come again. List again in the month of July or August, whatever. Final hearing.
27. Kumar BT.
One issue was observed last time in respect of alienations made after the coming into force of the Act. The Lordships noted that question of law, that where there is a prior permission to be required from the government and the alienation is made without that permission, it offends public policy. Therefore, the validity of such a contract, in view of such validity, whether delay will apply, that question was raised by Lordships last time.
Where is that order?
That order was the last. Yes, okay.
The last date, on the request of counsel for appellant, the case is adjourned.
It was the issue raised. It was not observed. It is not observed. That was the issue raised. The validity by virtue of section 23 of the Contract Act, in case such a validity is there, because after the coming into.
All right, let it come before the regular bench.
Yes,
Already admitted. Already admitted. Let it come for hearing.
Please. Stay to continue.
List in the month of August for hearing.
Please. Okay.
Application serial number 28. Charges Prasad.
Office observations on application as well as in the contempt petition.
Nobody appears.
Hari Prasad.
None appears. IA 1 of 2022 is considered. List for list along with record. Give it.
July. Passport matter, serial number 4. APO for the accused. The petitioners. May I pass on the complaint, Shafi David?
You given copy to him?
Yes.
No, revenue record has been corrected.
Yes. I have also produced the revenue records. The order also has been passed, Annexure R1, translated copy at page 7. Bottom order question is in the bottom. Last paragraph.
Yes, Mr.
One submission, my lord. In the RTC, they have not mentioned the interim order as it has been stayed. It has to be entered in column number 11. It has not been mentioned. That also was requested in our representation. That they have missed it out. Just because based on this RTC, they have
Now come to page 7. What has been done? Please explain.
Lords, what had happened was Deputy Commissioner has passed an order.
Which was stayed by the writ
Which
court.
was stayed by the Lord.
And even in spite of that, considering that the entry was made in the revenue record.
Yes, the Deputy Commissioner's order was given effect to and that was brought into the revenue record.
Yes.
Then, my lords, they gave a based on the representation, my lords, which came to their light after they have done this, my lords, even that was entered into even the stay order was also entered into. But, my lords, what happens, my lord, Deputy Commissioner's order once it made, my lords, from their office itself, my lords, in the software they have initiated this proceedings, my lords. That is why, my lords, we could not redo it, my lords. After the last date's order, my lords, we have removed all that and reinstated the names which were there previously. Now, since it is stayed, so it has gone back to that. Now, hence we mention a stay there, my lords, because stay was also mentioned subsequently, but we had to remove all that to reinstate the petitioner's name. Now the khata stands in the name of petitioner. After the disposal.
Show. First read the order. Page 7.
Page 7 on.
Implementing khata to Munivakappa.
Name of
Survey 24 bearing.
Yes, there are, my lords, in total 6 survey numbers, my lords. 5 survey numbers. Survey number 24, survey number 35, survey number 38. These 3 properties were standing in the name of, my lords, Nanjegoda, son of Sonnegoda. It has been reinstated to his name.
Okay.
Similarly, my lord, survey number 35 and survey number 39. These were in place reinstated in the name of Nanjegoda and Sonnegoda. The previous one, Munivenkappa, son of Sonnegoda. For their names, it has been reinstated. It was standing in their name.
All right, now come to the revenue record where their name has been entered.
What they are making submission, my lord. 22nd, the court passed interim order. 24th, immediately we made an.
Forget about all that. Now come to the whether the order has been complied or not.
They purposely changed it in the office, my lord.
All right, forget about all that. Now whether it has been complied or not.
My lord, mutation also has been changed, my lord. Mutation order also they have changed, my lord, but that order is not produced here, my lord. Only RTC they have given us, my lord. Copy of RTC.
Annexure R2, my lord, page 8, sorry, it is in Kannada. Mutation has been changed in respect of, after this giving effect to, my lord, in respect
In
of
the revenue record, name has been entered.
and it stands as it stood, my lord.
Didn't fail a response to this.
The order we have passed and we given that to 24 hours. This order is correct.
Send to Bhumi to take.
Already this order corrected.
Yes. So the order is correct.
Only thing is that you have not mentioned the interim order passed by the writ court. But the order has been complied.
Yes, what happened under the only one submission is we entered the interim order also after they that was also entered. But if the
In the earlier order you had entered it, but there the commissioner order was all implemented.
a commission, after the commission.
Even in, after noting the interim order passed by the High Court.
Yes, that was also entered.
But now this time you have corrected the revenue record,
Revenue
but you have
entry.
not mentioned the interim order
Interim.
passed by the High Court.
Yes.
We'll record your submission. We'll dispose of the matter then. Now order has been complied. We're recording this, we will dispose of. This contempt petition arises out of order dated such and such. The compliance affidavit filed today by respondent is taken on record. Note down the appearance of the accused respondent. So and so is present. In the first write that, then write this. On the last date, dated 10th of June 2022, we had passed the following order. Note down this order. The London AGA appearing for respondent submits that in compliance of writ court orders, the order dated 10th of June 2022 has been passed and necessary correction has been made in the revenue records, entering the name of the complainant petitioner.
It is restoring, because earlier my name was there. They have to restore.
That is the name of the complainant petitioner has been restored, ignoring the Deputy Commissioner order dated 8th of November 2021.
Yes.
21. Full stop.
8/12/2022.
8/12/2022.
The relevant copy of the relevant order dated 7th, yeah, 10/6/2022, and the translated copy of the relevant records of rights and Pahani are placed on record as R1, R2, and R3
R7 up to R7. R1 to R7.
up to R7, R1 to R7. Then the counsel for the petitioner complainant has been given copy of the aforesaid documents. Prima facie, it appears that the order passed by the writ court has been complied. In view of above, we drop the contempt proceedings against the accused respondent at this stage. However, with a warning to respondent to be more careful in future.
Great. Much obliged. Great.
One more survey number, it is missing, right? Survey number 39.
The contempt petition is stand dismissed. What is it, sir?